In May 2019, Redalius Ryan, known as Lil Rod, was formally charged by a Fulton County grand jury with first-degree murder aggravated assault and violating the Street Gang Terrorism and Prevention Act tied to the killing of 15-year-old Jamari Holmes, and the case quickly drew serious attention due to its gang-related claims. After a full trial in 2021, the court found Mr. Ryan guilty, and he received a life sentence, which marked a decisive outcome in the prosecution of the case and reinforced the severity of the charges. On October 23rd, 2022, during the high-profile racketeer-influenced and corrupt organizations Act conspiracy proceedings involving young Thug the State, presented Detective Al Hogan of the Atlanta Police Department, who had led the original Holmes investigation, and was called to provide detailed testimony about the earlier conviction. Prosecutors moved to use Mr. Ryan's conviction as a supporting act to establish the presence of the Young Slime Life Group, often referred to as YSL, as an organized criminal enterprise under the law. Under the Georgia RICO Statute Section 1614 for the state, is required to prove that members were involved in a continuing pattern of racketeering activity, which means at least two connected acts carried out to advance a shared illegal objective, and this standard became central to the courtroom argument. After the initial questioning by Deputy District Attorney Adam Abate, the defense attorney Leah Abasai, representing Mr. Ryan, carried out a detailed cross-examination aimed at challenging the claim that his actions were linked to a larger coordinated organization, and she pressed to separate his individual conduct from the broader allegations tied to YSL.
Into today, have you had a chance to review the interviews you did with the witnesses you spoke to?
Not all of them, but yes.
Okay. You haven't had a chance to review them?
I haven't reviewed, I reviewed Mr. Mitchell and Mr. Uten's recently. The others have not.
Okay. All right. So I want to start. You've been an officer for quite a while, yes?
Yes.
And so you know that when you are getting information from people, it is of the utmost importance to make sure it's accurate, right?
Yes.
And that's one thing you were doing with Ms. Smith, is confronting her with facts to test whether what she was saying was accurate, correct?
That's correct.
All right. And especially in a situation kind of with young people, they may not always be fully forthcoming in the beginning, correct?
It's not limited to young people, but yes.
Right. Especially if they think there's something they could get in trouble for, correct?
Yes.
All right. And the folks that you were speaking with in this situation, they were not, well, the two young men you spoke with, they were not lawfully allowed to have weapons, were they?
No, I don't think so.
Okay. So that's something they theoretically could get in trouble for if they admitted to it?
Yes.
Okay. So when you're speaking with them, when you're speaking with Ms. Smith, you're asking questions to make sure you can verify things. One of the things you told Mr. Mitchell you would do was get his Instagram records, correct?
I may have. That doesn't come to mind off the top of my head, but it would be something I would do, but I don't remember if I told him that.
Would it help refresh your recollection to see a copy of a transcript from that interview?
Sure, yeah.
So were you planning on getting Mr. Mitchell's Instagram records?
I may have been. It's hard to say. This is a lot of years ago, so it's part of my tools that I use for in each or any case that I have that I work. If there's an opportunity to pull those, and I need those, then yes. But I don't remember if I wrote a warrant for his Instagram or not.
Okay. You said if you have the opportunity, you certainly had the opportunity, right?
Yes.
Okay. And with those, if you had them, you could come back to him and say, hey, was this true? Was this not true from what you told me, correct?
Yes, I could, yeah.
Okay. And Mr. Mitchell and Mr. Uten, they were both cooperative, correct?
Yes.
So if you wanted to follow up with them, they gave you no indication that they wouldn't speak to you or anything like that. They were readily available.
Yes, not at the time they were cooperating with me that day, yes.
You didn't attempt to contact them any other times, though, did you?
I don't recall doing so, no.
Okay. So in this case, do you recall what search warrants you did take out?
No, not all of them, no.
Okay. Do you recall taking out warrants for Instagram records?
I do.
Do you recall whose records you requested?
I know I got little rods, I got Bally's, and without going through the index on my report, I can't tell you exactly, but I know I got little rods and I got Bally's. I got Rodelius Ryan's and I got Damon Blaylock's. May have gotten Mariah's and Brazy's as well, the Tyara Hartfield and Miss Smith.
Okay. What was your purpose in getting those records?
It's to any information there that might help with the investigation.
Okay. Did you look at those records?
Not personally, no. I looked at some of the pictures. It comes in a format. Again, as I indicated, I'm not a computer guy. I'm not even on social media. I gave that information to somebody who could put it in a format that was easier to read, and then those people looked through it, and they let me know what they found.
So it wasn't for you to get more information. Someone else was supposed to get more information.
The information is going to come to me. It just didn't come through me.
So at what point did you get the information of what was contained in those Instagram messages?
When they gave it to me. I don't know what day it was.
Who's they?
I don't remember who the analyst was that did the examination of those records.
Okay. And the examination of those records, I would assume you included in your report?
Some of them, yes.
Some of them. Could you let me know then when? I assume if you put them in your report, it says then when you got them, correct?
It says when I put it in the report. Let me see.
I mean, that's something you would put in the report, right?
One that jumps out at me was from February the 26th of 2019. Somebody sent me an Instagram post on that day, and it was a short video that showed Mr. Ryan riding in a car.
Okay, but that's not the Instagram records, right?
It's from Instagram.
That's not the Instagram records for which you obtained a search warrant to get so you could get more information, correct?
I haven't verified it, but if it came from his Instagram and I got a search warrant for his Instagram, then yes, it would be in there.
Right.
I just got it before I got the search warrant records back.
I'm sorry, if you could repeat that last part.
It was posted. Somebody saw it. They sent it to me. If my search warrant had not been executed and the information sent back to me at that time, it would be included in both records, but I got it before the search warrant records came in because somebody sent it to me right after it was posted.
Okay. I think a second ago, because you said you didn't confirm it, right?
You're going to have to, I don't understand what you're saying. I've confirmed it. Yeah, what are you talking about?
Well, I think about the content of the messages, you said you did not confirm with the records.
I just said I'm assuming.
Right.
If it's in his Instagram records, I received it before the records came back from the search warrant. I'm assuming that that information that I received that day before the records came back would be in the records when they arrived to me.
Okay. So without those records, having looked at them, there was no way for you to go to Ms. Smith or Mr. Mitchell or anyone else and say, hey, you told me X, Y, Z, but your records say something completely different. Right?
I did not do that, no.
Okay. You could have done it though, right?
Yeah, sure.
And that would have been confirming, right?
Sure, yeah.
Ms. Bayside moved to challenge the reliability of Detective Hogan by pointing out clear gaps between what he told the court and what he originally documented during the investigation. And this approach focused attention on how his account had shifted over time, which is a key method used in courtroom practice to test the strength of a witness statement. In legal terms, this strategy is known as impeachment, which allows the defense to question whether a witness can be trusted by highlighting differences between earlier records and present testimony, and it is a powerful tool when those differences are significant. Under Georgia rules of evidence, a witness can be directly confronted with prior statements that do not match their current version of events, and the court may weigh those inconsistencies when deciding credibility. In this situation, Detective Hogan's original report from 2019 described only one shooter at the scene, which stood in contrast to how the events were later discussed in court, and this created a critical point of tension in the testimony. During cross-examination, he also admitted that he did not reach out again to the witness after that initial contact, even after reviewing Instagram records that did not align with the witness account. And this lack of follow-up raised further questions about the thoroughness of the investigation and the reliability of the conclusions presented.
I want to ask you about what you testified to earlier about the actual crime scene. Mr. Abadi asked you questions about where you found certain things. Do you remember that?
Yes.
And you answered questions about where you found those 7.62 shell casings, right?
Yes.
But you didn't actually find those casings, did you?
No, I did not.
Those photos, you weren't there when they were taken, right?
No.
You never saw where those 7.62 casings were.
Not physically, no.
So when you say you found them, you didn't find them. Someone else did.
I said they were found. I'm not sure that I said I did.
Okay. When did you learn about those casings?
Later on the same day that the murder happened. I was at the office when I got the call.
Okay. And when you spoke with Mr. Mitchell and Mr. Uten, were you aware of those casings?
As I recall, it was around the same time. I don't remember exactly the sequence of events, but I spoke with them later on in the morning. It was sometime around the same, a lot of things were happening at the same time, that we got the call about the shell cases. That's one of the reasons I did not physically see them, because I was busy at the office. So I asked the responding officer to collect them and supervise them. But I don't remember the sequence of when exactly they came in.
Okay. Would it help refresh your recollection to see a copy from your trial testimony?
Sure.
I'm sorry, not your trial testimony, the last proceeding, several proceedings ago.
Okay, sure. All right, so what's your question again?
If when you spoke with Mr. Mitchell and Mr. Uten, you were aware of the 7.62 shell casings?
I was aware that they described to me two shooters, but I don't recall if I knew about the shell casings at that time. I may have, I don't remember.
You said that they described to you two shooters?
Yes.
Okay. You've got a transcript in front of you, so you've testified about this before, correct? Does this matter?
Yes.
Okay. And you don't recall the attorneys asking you at length whether anyone besides Ms. Smith mentioned two shooters?
I'll read here that they were asking me about that, yes.
Okay. And your testimony was that Ms. Smith was the only person who said there was two shooters, right?
Yes. That's what it says here.
I mean, when you...
Wait, before we get too far around here, let's make sure we got the right context. On page 1076, as I recall, they were asking me about my interview with Ms. Mitchell, and I had mentioned to her that I had two sets of shell casings. Mm-hmm. They were trying to determine if she... Okay,
well, I don't need you to testify about what someone else was trying to do.
So what I'm saying is context matters. In this particular instance, I was describing my interview with her, and in the process of the interview, when I was confronting her with the evidence, I told her that I had two sets of shell casings.
Yes, I understand that. So having reviewed that page, Mariah was the only person who said there was two shooters, right?
According to that transcript, yes, ma'am.
That was your sworn testimony under oath, right?
That's what I said, yes.
All right, so that was the truth that you said then, right?
Yes.
And I'm going to back up for a moment. I think you said Mr. Mitchell and Uten, they told you about not 7.62, but a weapon which would have fired larger shells. Is that right?
Yeah, they described a long gun coming out of the breezeway. Yes.
Okay. And when you were speaking with them, that was not consistent with the scene as you had seen it, right?
Again, I don't remember exactly when I got all the information about the shell casings. So at that point, I was getting his statement, and I took it as he gave it to me.
Did you not previously testify about the shell casings? I did not know about it when I interviewed Mitchell and Uten.
Okay, well, if my recollection was that then, I don't remember that now. If I didn't know about the shell casings then, if that's what I said, then that's what I said.
Okay. But you didn't confront them with what, at that time, would have been their testimony inconsistent with the scene, right?
No.
Okay. And they both told you one shooter. The number of shooters they told you was not the same as Ms. Smith, correct?
That's the same question, just worded differently.
We've already been through this.
I'm going to overrule that one.
Bernard Mitchell described the shooter coming out of the breezeway, and also the shooter when he was going around. He was right beside he described the person right outside the car shooting in the car.
So that would be
dreads and a hoodie.
So that would be he described to you two shooters, based on what you just told me.
Yes, based on my just reviewing my interview with him the other day.
Ms. Abasai then pressed deeper into the investigation by focusing on what she described as a major gap in Detective Hogan's approach, and she directed attention to his decision not to question the surviving individuals about their own actions during the shooting, which raised serious concerns about balance and completeness in the case. Standard investigative procedure and the Law Enforcement Code of Ethics require an officer to carry out a full and neutral inquiry that explores every possible angle, including those that could support the defense as strongly as those that point toward guilt, and this duty applies equally to witnesses and survivors present at the scene. During cross-examination, Detective Hogan acknowledged that he did not ask the surviving individuals, Mr. Mitchell and Mr. Uten, whether they had fired a weapon during the incident, and he also confirmed that no effort was made to search for any firearms they may have had in their possession at the time, which left a critical gap in the fact-finding process. Under the Best Evidence Rule, Section 2410-10,000, and two cases involving multiple calibers require careful tracing of each projectile to determine its exact origin, and this step is essential in building an accurate reconstruction of events. By not fully accounting for ballistic findings or conducting standard forensic procedures, such as gunshot residue testing on Mr. Uten, the defense argued that key evidence was left unexamined and that the investigation failed to consider the possibility of a shared confrontation scenario, which left several important questions unanswered and weakened the overall reliability of the state case.
What were the warrants you took out for Mr. Ryan?
For murder.
The only person who ever gave you any indication that Mr. Ryan knew Mitchell, Mr. Uten, the victim, anyone in the car, was Mariah. She's the only person who said they knew one another, right?
That you confused me a little bit. Say that again. Say it again.
The only person who said that Mr. Ryan knew Mr. Uten, the victim, Mr. Holmes, Mr. Mitchell, only person who said they knew each other was Mariah, correct?
I don't recall that.
Did you look at your interview?
Well, I'll be honest with you, I did, but I forgot what you asked me for to be looking for in there.
Okay.
Maybe it's a question. Ask me each person at a time. So, Mariah, you're saying Mariah said she knew Mitchell.
Mariah told you, was the only Mariah indicated, whether through this or something else, Mr. Ryan had some contact, knew the existence of Mr. Uten, Mr. Mitchell, Mr. Holmes, right? You never went to any of them and said, hey, do you know this guy?
No.
Okay. And they never, gave you any names saying, I think it was this person or I have a problem with this? Nothing.
They who?
Mr. Mitchell and Mr. Uten.
They said they did not know who shot at them.
Had no idea.
That's correct.
And didn't ask them if they, had any problems with Mr. Ryan or Mr. Blaylock, right?
Yeah, they said, yeah, they're correct, yeah.
Okay. And Mariah, she never told you anything about being locked in a basement, did she?
I don't recall that, no.
Okay. And she didn't tell you anything about Mr. Blaylock attacking her, did she?
Other than when Mr. Blaylock. Oh, no.
Okay.
No, not that I remember.
All right. And so based on the evidence you had, the person who fired the 7.62 was tall, right?
I was described, he was described as being tall, I believe. Just
All
a
right.
second. Let me double check it. Just a second.
And I can get you a transcript of your interview with Mr. Uten if that further helps too.
I bet you can. Let's see. Yes.
Okay. So Mr. 762 is tall, and based on all of that evidence, was your conclusion that Mr. Blaylock was the one with the 762, right? Page 18?
Page 18. Of what? Which one am I looking at?
Your report.
Well, if you got a page 18, you're doing better than me. I got 17 pages.
Oh,
Okay, I see what you're referring to, yes.
yep. So final conclusion you came to based on everything you reviewed was that Mr. Blaylock had the rifle.
That's what I...
Detective Hogan confirmed under cross-examination that Miss Bayside line of questioning centered on the identification of Damone Blelick as the alleged second shooter, and this became a key issue in evaluating the strength of the case presented to the court. It was established that arrest warrants were not issued at the scene, but were instead obtained later based on early eyewitness descriptions, which raised concerns about how those initial accounts were relied upon over time. Miss Bayside argued that the investigation showed a basic failure in standard detective procedure because it did not first determine whether the individuals involved had any prior connection or history of conflict, which is a critical step that can shape the entire direction of a case. Without confirming whether the parties knew each other or had any rivalry, the defense maintained that the claim of a gang-related attack lacked a solid factual base and appeared to have been applied after the investigation rather than discovered through it, which challenges the principle of due process that requires evidence to come from objective inquiry. The defense also pointed out that the probable cause used to obtain the warrants relied on a flawed summary of facts, since it did not address differences in witness descriptions, such as height, and failed to establish any clear link between the individuals involved. In Miss Bayside view, these gaps show that the investigation did not meet the level of evidentiary reliability required to connect Mr. Ryan to the alleged YSL enterprise, and left the case open to serious doubt.
All right, so we have rifle rounds, and then we have all these other casings from a smaller gun, from a 9mm, correct?
Yes.
All right. And those casings were found very, very close to the vehicle where the victim was, correct?
There were casings on top of the car, yes.
Okay. And casings on top of the car, you don't know how they got there, did you? Or do you?
I didn't see them be placed there or fall there, no.
Okay. Did you speak to the EMS, the emergency services people who would have been there responding?
They were gone when I got there.
Okay. So you're not sure whether they had to move anything to get to Mr. Holmes?
It was obvious that the hat we found on top of the car was placed there by someone.
Right.
I don't know who. But I guess it's plausible that somebody would say, hey, there's a shell casing, let's put it on top of the car.
Yeah. So they wouldn't want to lose it.
Don't know why they do that, but yeah.
Okay. So you discussed with Mr. Mitchell and Mr. Uten whether they had guns, correct?
Yes.
They both had guns, right?
Yes.
And you never asked them if they shot, did you?
Mitchell said his gun was empty.
Okay.
Uten, I don't recall ever asking that specific question.
Right. You didn't ask him what kind of a gun he had, right?
I don't recall asking him.
You asked him what happened to it, though, later, right?
Yes.
And he indicated to you that you should...
All of this is hearsay. What Mr. Whoever indicated to whoever.
Sustained.
Okay. Did you have an occasion to either you yourself or have somebody go looking in the woods for a firearm?
Wasn't me, but yes.
Okay. And beyond that, you did not have any follow-up to tracking down those guns, right?
That's correct.
All right. And your reason for that, you previously testified, was you had no reason to, right?
I had no further leads. Once we tried to find them and couldn't, based on where they said they put them,
Okay.
there was nowhere else to go.
So you had no reason to try and find out whether Mr. Uten was the one who fired all those 9mm.
Say that again?
So you had no reason to try and figure out if Mr. Uten is the person who fired all those 9mm.
Right, I didn't try.
Because if he did, that would be your second shooter, right?
Your Honor, objection calls for speculation.
Sustained.
You, at some point, had an occasion to review Mr. Mitchell's Instagram records, correct?
Again, I'm not a computer guy.
Far later.
I allow other people on the team examine those. I trust them in what they can do because a teenager is better than me on that stuff.
Yep.
So I looked at the report or what was given to me. Did not do a deep dive, no ma'am.
No. No deep dive. You didn't look at them.
Say it again?
No deep dive. I mean, you did not look at them, right?
I don't recall if I did, yeah.
Okay. So you never did any follow-up with Mr. Mitchell about him shooting back, did you?
No.
But you learned that at some point he said he did, right? Or they did.
Yes, I did hear that, yes.